I would like to virtually welcome you to the Institute, which you can hopefully see in the background, and to our very first online Supranational Criminal Law, or SCL lecture. For those of you who are not familiar with this, the SCL lecture series is a series on international criminal law and has been organized since 2003 by the Instituut in cooperation with the Coalition for the ICC and the Grotius Centre for International Legal Studies of Leiden University. And tonight's webinar is moreover co-organized by the International Humanitarian and Criminal Law Platform, which is an interfaculty research platform on international humanitarian law and international criminal law in which various Dutch and Belgian organizations and universities participate. Tonight's webinar is entitled Challenges to Prosecuting Paramilitaries, Insights from the former Yugoslavia and Syria. Paramilitaries and irregular armed forces are and have been omnipresent in conflicts around the world, from Latin America in the 1970s and 1980s, to the former Yugoslavia in the 1990s, and more recently in Iraq, Syria, and Ukraine. And many of them have perpetrated brutal attacks against civilians and participated in crimes that have been legally qualified as genocide, crimes against humanity, and war crimes. Now, these armed groups often assist regular state forces, and various units act covertly in pursuit of political and territorial goals, which enable states to claim plausible deniability and leaders to escape responsibility. A number of trials in The Hague at the International Criminal Tribunal for the former Yugoslavia, or ICTY, and the Permanent International Criminal Court, or the ICC, dealt with various paramilitary units. And the International Residual Mechanism for Criminal Tribunals, which is mandated to perform a number of essential functions previously carried out by the ICTY and the International Criminal Tribunal for Rwanda, the ICTR, is currently retrying an important case relating to the paramilitaries in the former Yugoslavia, prosecuting state officials for establishing, funding, and directing units that committed crimes in Croatia and Bosnia and Herzegovina. Tonight's panel will discuss, from an interdisciplinary perspective, the nature and purpose of paramilitaries using examples from the former Yugoslavia and Syria, as well as the legal, investigative, and evidentiary challenges in prosecuting perpetrators, both paramilitary members and those who command and control them. And for this, we have three fantastic speakers for you. The first speaker will be Dr. Iva Vukušić. Iva works at Utrecht University and is a visiting research fellow at the Department of War Studies at King's College London. She completed her PhD in Utrecht, focusing on Serbian paramilitaries and irregular armed forces during the breakup of Yugoslavia. Iva worked for the Sense News Agency in The Hague, analyzing evidence from trials at the ICTY, and before that she was an analyst and researcher at the Special War Crimes Department of the State Prosecutor's Office in Sarajevo in Bosnia and Herzegovina. Recent publications include an article about the Scorpions unit in the special issue Images and Collective Violence, Function, Use and Memory in the Journal of Genocide Studies and Prevention, a chapter on the challenges of prosecuting paramilitary violence in Perpetrators of International Crimes, Methodology, Theory and Evidence, published by Oxford University Press in 2019, and a chapter on Justice Options for Syria in New Critical Spaces in Transitional Justice, published by Indiana University Press in 2019 as well. And Iva will speak on Serbian paramilitaries' insights from the ICTY. After that, we'll move our focus to Syria and listen to Ali Aljasem, MA, who will speak about the rise of Kataeb al-Bad, the al-Bad legions at Aleppo University after 2011. Ali is a researcher at the Netherlands Institute for War, Holocaust and Genocide Studies, NIOT, in Amsterdam, and a research fellow at the Center for Conflict Studies at Utrecht University, focusing on paramilitary groups in Syria. And Ali is also part of an international team collecting evidence to criminalize the use of starvation in Syria as a means of war. He's a guest lecturer at Utrecht University and the Amsterdam Center for Middle Eastern Studies. He's also the Syria consultant for the Dialogue Advisory Group, and formerly he worked for Médecins Sans Frontières as a security advisor in Aleppo and an ideology analyst in Amsterdam. And last but not least, we'll listen to Dr. Matthew Gillett, who will address the issue of establishing the liability of paramilitary members for atrocity crimes, and both look at problems and potentialities. Matthew is an international lawyer and academic with over 15 years of professional experience, and he currently works as a trial lawyer in the Office of the Prosecutor at the International Criminal Court. Previously, he served as a human rights officer with the United Nations Assistance Mission in Afghanistan, as a prosecution attorney at the ICTY, and as a defense barrister and judge clerk in New Zealand. And in 2010, he was a member of the New Zealand delegation at the Kampala Review Conference of the International Criminal Court. He is a director of the Peace and Justice Initiative, and he's the IBA Special Rapporteur on the crime of starvation. Now, to all three of you, I would like to thank you, of course, for your willingness to share some of your insights with all of us. Now, all panelists will speak for maximum 10 minutes each, after which I will open the floor for a general Q&A with you and the people watching at home. If you have any questions, please use the chat function, which you will be able to find in the bar below. And please also specify to whom you are directing the questions. And now, without further ado, I would like to give the floor to Iva.
Thank you very much. Good evening, everyone. Good evening, Christophe, and to my fellow panelists. It's a real pleasure to be with you tonight. And let me now try to share some of the insights from my PhD and related research. And I'm going to be focusing on Serbian paramilitaries and insights from the ICTY. So let me just say that I want to make 3 points tonight. So I want to discuss briefly the definition of what is a paramilitary. And I want to stress the diversity of units, so the diversity of units that we saw in the field. I want to briefly discuss plausible deniability, and in particular, the way plausible deniability works in practice. I'm going to be discussing a concept I call ambiguity, which is, I argue, most often produced and maintained on purpose. And finally, I'm going to speak briefly about some of the difficulties of prosecuting leaders for paramilitary violence, especially when it takes place across a state border. So proving links across state borders is challenging, and that's actually why some of these units are very useful to leaders, and I'm sure Matthew is going to probably refer to some of that. So before we start, I just want to say one thing about doing research in ICTY archives, and I'm speaking as a historian. My PhD was in history, so the ICTY archives provide a lot of opportunities and challenges, and 2 things about them are both an opportunity and a challenge at the same time, and that is the enormity of the record, so the millions and millions and millions of pages that are available that have been assembled at the ICTY in 25 years of its operations. But also a challenge. One particular challenge is inaccessibility of an important part of this record. Classified documents, for example, from relevant trials. Now I would like to just say and praise basically the ICTY and the residual mechanism for giving access to researchers, to historians, to this record, because other international tribunals normally do not provide access to evidence material, and the ICTY does. And I would like to plead for as much access as possible, while at the same time, of course, I fully understand that not everything can be declassified, nor it should. So within reasonable limits, but I would like to invite, maybe we can come back to this a little bit later, but invite a discussion about classified nature of documents and sort of the process, how one researcher could go about getting some of those potentially. So let me move to definition of the unit. So this is very much imperfect, and we can discuss it later, but I basically use a definition that has 5 criteria. So for me, for the purposes of what I was doing, a paramilitary is a group which is armed, it is organized, so it has a certain hierarchy and a certain structure. It has a political goal, even if that political goal is not necessarily publicly stated or publicly proclaimed. The unit is recognizable in some way, so it has a name or some insignia or some way to differentiate it from other groups of people. And finally, and importantly in my case, a paramilitary unit is one that is not part of a regular police or army at the time of the establishment. So examples of some of the units that I studied, and this is by no means fully exhaustive, because anyone who knows the former Yugoslavia will understand that there was a multitude of units and many, many of them in many different places throughout the decade. But some of the names are, for example, the so-called Red Berets, the Arkan Tigers, the Scorpions, the Avengers in East Bosnia and Visegrad, for example, some of the Šešelj affiliated units, or the so-called Chetniks, and the Yellow Wasps, so also a unit that was very active in Eastern Bosnia. So In a sentence, basically, what I hope to bring is that to this discussion is the conclusion that this story about Serbian paramilitaries is much more complicated than we normally assume, or that we normally understand. To make a broader point about diversity, I want to say that from my research, it appears that some units were much more centralized than others. Others were more like a conglomerate of units acting under one umbrella as opposed to a unified structure. They were also different in what their purpose was, their closeness to the government, and this is the dynamic relationship which can also change through time, and we see this with units in other armed conflicts as well, that this relationship with the government can be very much up and down, closer and then further away. Units are different from one another also in the way that they recruit and train their members and who they recruit. For example, in terms of age, in terms of physical fitness, those kinds of things tend to vary, and how and where they engage. So some units are much more mobile than others. So they move through spaces and then they interact or they attack civilians that they don't know, while some are very local. So in those cases, the paramilitaries will attack people that are their neighbors or that they went to school with. And finally, one important insight is that paramilitaries can also differ in the ways that they attack civilians. For example, my research showed that some were much more likely to engage in, for example, sadistic kinds of torture and sort of acts that created harm on a person almost just for the fun of it, and not kind of an instrumental act where some units, for example, beat people sometimes to death or shot them, but then moved on, didn't really spend much time on, for example, torturing and really tormenting their victims. I differentiated in my research between two different kinds of units, and if someone is interested, we can come back to this later, but basically I divided them into main categories. One were kind of professionalized units, and the other ones were non-professionalized units. But for now, I'll leave it at that, and then if someone is interested, we can come back to that. A second point that I really want to discuss is plausible deniability and ambiguity, as I already announced. So research suggests that one of the main reasons why governments use paramilitaries, especially for illegal, illegitimate, and unsavory acts, is precisely plausible deniability. And it's basically about creating a sufficient amount of confusion to evade sanctions for states, evading the diplomatic pariah status, so to say, for a state, and possible also criminal prosecution for leaders, which is something that looms large, I think, for leaders, even when jurisdictional issues may be a problem at the moment. No one knows in 20 years' time what the future might look, and we constantly see that people who we thought were not going to be prosecuted still can end up charged and in court. So about ambiguity, basically what I want to say is that this is how plausible deniability is put in place. So it's the confusion that is manufactured and maintained to create this distance between political sponsors and units in the field. Examples of this that we have seen, for example, in ICTY trials, is units taking off insignia before going into action, or various members having multiple IDs at the same time, where it basically says that these individuals work for different agencies in different places, which of course then creates a confusion about who is ultimately responsible for this, who is the boss of this person, so to say. They had, for example, particular employment strategies, these units, in order to create and maintain this distance. For example, there was one testimony from a witness called Stoparić, who spoke about the Scorpions unit, where there was a rule that 40% of the members of the unit were supposed to be from Serbia proper and 60% from elsewhere, because by having the minority from Serbia proper, one could say, well, this is not a Serbian unit. Or hiring, for example, members like freelancers. you know, sort of without a deeper institutional commitment to paying their benefits or pensions or things like that. So there were a variety of ways in which a government and an institution can muddy the waters, so to say, about who's employed, when they're employed, what is the name of the unit that they're employed with, and who is ultimately responsible for that unit. What I want to say here, and I think it's an important takeaway, is that ambiguity is in this context not a bug, but it's a feature. It's something that kind of armed engagement. So it's something that is not easy to resolve who units belong to, and this is precisely the point. It's precisely the point that we don't easily make these connections about who's responsible for whom. It's supposed to be difficult, and that's sort of the idea behind it. And thirdly, something that Matt, I'm sure, is going to talk about much more, but the challenges in prosecuting paramilitary violence. So here I'm talking about not lower level members, because I think that is more straightforward, but higher level people that are far away from the crime scenes and where there are these ambiguities about who these units work for, so to say. So with prosecuting these higher level people that have responsibility, so for example, working for several ministries of the government or government agencies, what we can see from the ICTY is that much of the convictions, both at the ICTY and local judiciaries, are for lower level perpetrators. And higher level perpetrators, but only really if the person who is charged and the crime are within state borders. So if there's a state border in between, it tends to be much more difficult to create these links that will hold up in court and that will then lead to a conviction. And I think here we have good examples also from the ICTY where no one from Serbia proper has been, from state institutions, has been convicted for crimes in Croatia and Bosnia and Herzegovina, apart from the JNA cases, but this is the army. But what I want to say is that what we see from the ICTY's record in this particular regard, I would say, does not correspond to the situation on the ground, because there's quite a lot of agreement that a lot of these units were funded, supported, resourced, directed from Serbia. But where from in Serbia proper is a matter of some dispute. So it's very, and this is something that the residual mechanism is dealing with right now, is which institution is it that was responsible for these units? Is it the Ministry of Internal Affairs? If so, which bit of it? Was it the army? So there's dispute about who was ultimately responsible for these units, but this lack of conviction, I think, speaks to the difficulty of making those links and the difficulty of proving responsibility for units that act in the field across the border with changing names, dubious documents, where as I said, things are ambiguous. And finally, what I want to say is that states will not stop using paramilitaries and related to them, for example, private military companies, and in outsourcing violence for unsavory sort of business, especially across borders, as long as this formula works. And from the ICTY practice, we can see that it works quite well. So if you want to be committing crimes across borders, this is actually not a bad recipe, so to say. So we already mentioned one trial. There is a residual mechanism that is going on. That's really interesting and important. It has been going on for a million years, so I really hope that soon it will be over. But basically, I want to conclude just by saying that it remains to be seen how prosecutions will go in the future for crimes, for example, in Syria, and if these challenges of sort of establishing these connections and you know, making something stick in court are going to be similar. And I suspect that they will. Anyway, I'll leave it at that, and I'll be more than happy to answer questions. Thank you. I hope I was within time.
Thanks, Eva. Yes, you were. And thanks also for creating that very nice bridge to Ali. So no, thanks for that very clear presentation, also for touching already briefly upon the challenge of accountability and prosecution, and that will indeed be addressed in greater detail by Matthew later in this webinar. Now let's indeed move our focus from Serbia to Aleppo. Ali, you have the floor.
Thanks, Chris. I'm just figuring out how to share my screen. Yes. I'm sorry if it's going to take time, but I don't know how this works. Can you see my screen? No. Can you see my screen? No. Okay, so I'll drop that and stick to my screen. I'm sorry, it's just like complicated for me. So thank you, Chris, Asser, team, and good evening to everyone who's joining us today. I will indeed be speaking on paramilitary groups in Syria, or what Syrians coin as Shabiha, which is the local term that we use to describe paramilitary groups in Syria. Actually, my research project is on the paramilitary groups at Aleppo University. So it's very micro level case study, and I'm only looking at the student component of these paramilitary groups. So first of all, unfortunately I couldn't share the screen with you, but I would make a quick overview of the apparatus of courage in Syria. We have the army, the police, and the security services institutions or apparatuses. We have also other special forces, and then we have paramilitary groups. Actually, in the context of Syria, the Shabiha groups or paramilitary groups were not or are not a new phenomena. The Assad regime, the father Hafez al-Assad, used together with his brother Rifat, used such groups in the crackdown on the uprising in the 80s. Those people are very famous for their intimidation and kind of regime affiliation. So they are very much loyal to the regime rather than to the state. And Shabiha is defined by one of the Syrian thinkers, Yassin Hassaleh, who defines the Shabiha as a raw force which mirrors the structure and goals of the regime, whose aim is to accumulate personal wealth and ensures its own survival at all cost. So that is a very dominant feature of the Shabiha groups in Syria. And there are a lot of characteristics. Thanks to Eva, she has eloquently gone through the theoretical definition of the paramilitary groups, but I would like to add some stuff or characteristics that are special to the Syrian paramilitaries. First of all is that there are always brokers or in between people between the higher officials in the capital in Damascus and the local recruits. So you always need those brokers who act as liaison between the capital and the local population. In the case of Aleppo, where I look at my research, my findings identify three types of paramilitary groups. First, there were groups who were recruited through communitarian links, meaning that through tribal and clan networks. So the heads of clans, tribes would play a significant role in the recruitment. And the second type is the business or the crony type of paramilitaries. So Aleppo is the capital or the economic capital of Syria. So businesses are flourishing. Businessmen took the advantage of the uprising and used that as a way to approach to become a new elite And this is what we have been witnessing in the last decade. There were new faces coming to the fore, and just to take kind of a front seat and kind of expel the old guards, as they are called in Syria. So this is also very significant. So there were groups who were sponsored, or which were sponsored by businesses or businessmen. The last kind, or the third type, is the clientelist, or the political parties, or the Ba'ath party affiliated groups, which were recruited through the auxiliary organizations of Al-Ba'ath Party, which is the ruling party or the only ruling party of the country for 50 years now. However, my focus is only on the third type of paramilitary groups. We see this phenomena of students, teachers, engineers who take the initiative and go to the security services kind of heads, or branches heads, and offer their services. So this contradicts the classic kind of argument that civilians are victims of violence, and in my case I see civilians as also perpetrators of violence, or those who take the initiative to perpetrate or conduct violence against their fellow citizens or other civilians. So in the case of Aleppo, I look at these types of people. Unfortunately, I can't show you the picture where you see men in suits, engineers, university professors, who are kind of the mastermind of such groups, which is very interesting. Those are kind of taking up high positions or senior positions in these groups, where they don't have any military backgrounds, and this is like a very interesting a point where if we compare the regular armed forces, the military, we see they are organized along hierarchical lines, and there is clear command structure. While at the within the paramilitary groups, we don't see these hierarchies. We see, as Linders called, hierarchical structure. You see the chain of command is through social status, and also through civilian positions. You see the head of the Al-Ba'ath branch is the mastermind, and is the sole ruler and leader of the whole paramilitary structure. So this is very interesting to see the difference between the structures of a regular paramilitary group and a regular armed force and a paramilitary group. One final thing is actually through my research, I was following some key figures who played a role in the recruitment in the Syrian case, or in Aleppo case, where they were kind of claiming the ladder, or gradually being promoted and rewarded for all the services that they have been providing to the regime. They are young people who got higher positions at the, for example, at the parliament, at the Ba'ath Central Command. So it is very clear how the regime indeed used this to play the plausible deniability, but at the same time to reward those who would do them a favor. I would like to conclude my presentation with a quote from one of the Ba'ath legions or Kataib al-Ba'ath members. He's a senior member. And I'm quoting that, and by applying the Leninian question of to Kufa, or who will control, will overtake whom, which can better explain the nature of the relationship between the masters of violence in Damascus and violence brokers in the periphery, Aleppo. The leadership, here I'm quoting, the leadership in the capital thinks that they are the biggest winners with the minimal expenses and damage, while the new rising elites in the case of Aleppo see themselves gaining great advantages by being promoted to positions they would have never thought of occupying otherwise. Thus, actors internal to the community played a significant role in the civilians' mobilization in the context of Aleppo. Sectarianism was the least factor concerned in the context of Aleppo University. What matters is the social status. And I'm happy to answer questions, and I hope that I didn't exceed my time.
No, not at all. Thanks a lot for respecting that time slot, Ali. Thanks a lot for your very interesting presentation. I think also the issue on the loose organization of these groups that you mentioned will probably maybe evoke some questions in the Q&A with respect to the criterion of Iva, that these groups have to be organized. But it was also very interesting, I think, to hear more about how civilians are really dragged into these structures in the first place. Now, it has already been briefly touched upon, but how can we ensure that there's no impunity for the conduct of paramilitary groups? In the word of Iva, this formula, the outsourcing of violence, works. So what we can really do about this? So Matthew, can you share your insights with us, please?
Thank you very much, Christoph, and thank you, Iva and Ali, for that factual foundation that has set out the problem confronting international criminal justice. At the outset, I should say that if international criminal law is purporting to provide comprehensive justice to victims of these types of atrocities, it is going to have the mechanisms to make plausible deniability implausible and hold the leaders up to the highest levels responsible for their acts that they may seek to disguise through the use of these irregular structures. I'm going to provide a few comments in my own personal capacity. A lot of them will relate to jurisprudence from the Tribunal for the former Yugoslavia, primarily because I worked there, but also because, as Iva has mentioned, it has a rich archival resource that is open and can be cited, and including videos, other documents, and witness testimonies, and also because Syria, unfortunately, has largely not been addressed by the international courts. It's not really been addressed by the international courts to date, and so I think the lessons from the Tribunal for the former Yugoslavia and the other existing tribunals should be taken on board if there are to be future trials for the events in Syria. If we look to some of the characteristics that, let's say, present themselves in relation to paramilitary groups, indeed they do tend to be ubiquitous in complex multi-party conflicts, dynamic conflicts. For instance, the 1994 Commission of Experts report on the conflict in the former Yugoslavia noted that there were at least 83 identified paramilitary groups operating within those territories, and noted that all sides were using paramilitary forces of some description or another. There is also a consistent feature of ambiguity, which has been mentioned earlier. And again, the Commission of Experts noted that the paramilitary groups have lines of authority and structures of command and control that are confusing, even to the combatants themselves. And when I come to talk about proving crimes and responsibility therefore, you'll see that if even the members of these groups themselves are unsure and unclear as to their lines of command and response, it makes for considerable difficulties in marshalling the evidence together and meeting the beyond reasonable doubt standard that is applied in the international criminal institutions. As also noted, these groups tend to be, and there's no hard and fast rules, there's a lot of variation in these groups, but they tend to be involved in some of the worst atrocities that emerge. The Commission of Experts noted there was a frequent modus operandi where conventional military forces would, so to speak, soften up villages, towns, and other locations with artillery bombardment, and then more irregular paramilitary type groups would enter towns and villages and extract inhabitants from their houses and commit acts including murder, rape, and violent displacement from their localities. One of the examples that is in some ways emblematic both of paramilitary behavior at its worst, but also of the difficulties for international courts in addressing these crimes, is the execution of 6 Bosnian Muslims by the Scorpions paramilitary group in July 1995 in a location near Trnovo in Bosnia. And what was notable about this incident was that it was all captured intentionally on video by members of the perpetrator group themselves. On the video, you see the Scorpions fighters in their red berets taking the Bosnian Muslim civilians from the back of a truck. They're handcuffed, they're insulted by the Scorpions members, physically mistreated. 4 of them are lined up and shot, first in the back and then in the heads. 2 of them are forced to carry away the bodies, and then those remaining 2 prisoners themselves are shot and killed. What has been problematic, despite the existence of a video documenting the crimes, has been establishing responsibility at the higher levels for this execution. So, for instance, in the tribunal for Yugoslavia, in the multiple cases, these charges have eventually either resulted in acquittals at trial or on appeal been overturned and reached acquittals. So in the Popović trial, where many convictions were entered for events around Srebrenica, at the same time, July 1995, involving the same victim group, Bosnian Muslims, who were seen with these 6 victims of the Trnovo incident. Many convictions were entered for those other mass killings, but the Scorpions killing was overturned on appeal, those convictions. Similarly, in Tolomir, in Mladic, the acquittal was entered at trial. There was a conviction technically entered in Karadzic in the trial judgment, but it was not specifically addressed on appeal, so it remains on the record, but it's unclear how the appeals chamber would have approached it if it had specifically been litigated. So those are some of the top-level internal leaders, Mladic, Karadzic, within the Republika Srpska. Then if we shift, so within Bosnia, if we shift to across the international border to Serbia, there is an even bleaker record of accountability. So it's been mentioned in the Stanisic and Samarovic trial. There was an acquittal. They were charged with the Trnovo execution. That's now on retrial. Slobodan Milosevic, who was charged with this, died before his judgment could be entered. And then at the International Court of Justice, concerning state-to-state accountability, in the Bosnia genocide case, the ICJ noted that although there is documentation indicating that the Scorpions were a unit of the Ministry of the Interior of Serbia, it did not see their acts as imputable to the Serbian authorities. So there really is a lack of linkage that has been found by the international courts. Broadening the perspective, why are these difficulties emerging when it comes to paramilitary forces as opposed to regular conventional armies and police structures for which for instance, Tribunal for the former Yugoslavia has a much more robust record from the perspective of entering convictions on the basis of fulsome evidence? Well, partly it comes down to, as mentioned, their irregular structures, the lack of a conventional chain of command in some instances, again it varies, but also the fact that their hierarchy and chain of command will not typically be reflected in formal legal documents and regulations. Whereas in a typical case of an army or a police force, you have those regulations, the legislation or subordinate legislation that can be immediately entered into evidence and is very difficult to dispute, certainly at the de jure level. So already with paramilitary groups, you're generally in the de facto realm of dispute. And then there are these shifting constellations, membership changes, the personalities change, and you can, again, run through the various names of these groups, the Scorpions, Arkan's Tigers, Matich's Men, Sheshul's Men, Red Berets, Yellow Wasps, White Eagles. I mean, there's a real colorful cast of characters who sometimes shift between these groups and suddenly overlap and interact. The accompanying difficulty with this, and I mentioned earlier that sometimes the combatants are confused as to their own chains of command. Certainly, if they're willing to speak, these insider members of paramilitary groups, they will often not come to you clean-handed. They may well have been involved in atrocities themselves, and so obviously they're potentially impeachable on cross-examination by the defense. And they also often live quite itinerant lifestyles. Many of the original Red Berets are no longer with us. Arkan Raznjatovic, famous, infamous leader of Arkan's Tigers, was assassinated in the Hotel Intercontinental lobby in Belgrade. So it can be very difficult to secure the evidence from these witnesses. I'm aware of the time constraints, so I'll just shift rapidly, if you permit me a couple more minutes, to say this non-conventional typical structure then creates difficulties when it's superimposed onto international criminal law concepts and theories, particularly in terms of co-perpetration or joint criminal enterprise. So these are two modes of sort of liability for crimes committed by groups, and superior responsibility. And I won't, in the interest of time, go into huge detail, other than to say that both those constructs are very prevalent in successful cases from the prosecution perspective that have resulted in convictions, particularly in relation to crimes committed by groups operating geographically in a disparate location and maybe through several chains of command, whether de jure or de facto. But if we look at, for instance, the underlying theory of indirect co-perpetration, just to throw one out there, it's based on this concept of organized and hierarchical apparata of power characterized by near automatic obedience to orders. And a lot of this is based on an academic called Roxon, who says that by contrast, if you have half a dozen antisocial elements who join forces to commit crimes and choose one of their number as a leader, this is not yet one of these types of power structures in which you can impute up the chain liability for indirect perpetration. So we're already confronting conceptual, structural difficulties, which sometimes can be the point of using paramilitary groups. To throw out some of the ideas thinking about structures, mechanisms to address these problems, I think there are various modes of liability, and there is a level of flexibility in their interpretation and application. So for instance, there's also Article 25.3d at the International Criminal Court under the Rome Statute, so assisting groups carrying out crimes. And in terms of evidence, because ultimately, usually these issues come down to evidentiary issues, insiders like Ali mentioned, the brokers between perpetrators on the ground and financiers and high-level leaders, they could provide a valuable source of information if you secure them early and hand-in-hand think about their protection so that then they don't disappear, or securing their evidence. There are various mechanisms, deposition-type mechanisms, where you can take their evidence long in advance of a trial that may occur, and you can have a judge or judges present so that it's got effectively the status of testimony that can be used and preserved. Hand in hand is the idea of collecting other forms of evidence. So there are vast document troves that have been picked up from Syria that promise on their face to be a valuable source for efforts to hold people accountable. And increasingly digital evidence on various social media platforms and online, which if you can secure it, once you have it, doesn't change, unlike witnesses whose memories can fade, whose motivations can change. And finally, deep analysis. So seeking the input of academics, experts, expert witnesses as well, who really understand the local and regional context, the shifting sands that these groups operate in, and what's going on, so that you can use that interpretive tool to read the evidence that you get your hands on. Just to conclude, I'd say that whilst there are multiple difficulties, I think those of us involved in the International Criminal Justice Project owe it to the victims of crimes like Turnovo, like the families of those murdered Bosnian Muslims, to seek to ensure that there are mechanisms available to preserve the evidence and hold those responsible who are involved in ordering, assisting, supporting these types of crimes. Thank you very much.
Thank you, Matthew, for this very clear presentation. I think also the point you made about member shifting groups, the issue of loose organization, and it seems to be the core of the efficiency of these actors. And of course, this will also be the main challenge to achieve accountability. But I think you mentioned a couple of very interesting points that prosecutors should focus on. The brokers that Ali mentioned, digital evidence, deep analysis. So I'm very sure that these insights will be taken into account. I think that all three presentations have given us a very good idea of the sort of conduct paramilitaries group can commit, as well as the challenges and opportunities that the law can offer in this context of fighting impunity. We now have some time for Q&A with you and the people watching at home. And again, please make use of the chat function, which you will find in the bar below, and please specify to whom you are directing the questions. Now, a few have already come in, and the first question is actually to all panelists. And the question goes as follows. After Nuremberg, the international community failed to recognize the role of paramilitaries in armed conflicts. For example, use of paramilitaries by the Pakistan Army in the Liberation War of Bangladesh in 1971. Do you think the practice of impunity has played a role in the use of paramilitaries in the post-1971 armed conflicts? So maybe Eva, you could take this question first, and then the others can follow up.
Sure. Just briefly, I think impunity actually is a really important factor because, for example, one of the units that we were discussing, so the Scorpions, were committing crimes, and specifically the incident that many of you will know, so the Trnova execution of the Srebrenica victims. The fact is that many of these kinds of crimes at the time were not punished, were not investigated, were not pursued, and the commanders did not do anything to punish the perpetrators. And then, for example, the same unit, we find it in Kosovo 4 years later, doing similar kinds of acts towards or attacking in similar ways the civilians in Kosovo. So I would argue with impunity, the state or the authorities send a message about which crimes are tolerable, and which victims matter and which don't. And by doing that, basically it makes perpetrating crimes very low cost. If you know that it doesn't, it will not come back to haunt you, then you don't really, I think, care. So I think impunity, and this is actually one of the findings of my research as well, is that impunity during the conflict itself, when commanders, and other research points to this as well, when commanders make a point of isolating, investigating, and punishing people who attack civilians, for example, that very much has the influence on the broader behavior of the rest of the unit.
Yeah. Thanks a lot. Maybe Ali, would you like to follow up?
Yes, I would like to follow up. Is in addition to the impunity, you will have the reward. I can speak on as an example what happened in Syria. So you have also a guarantee that you will not be persecuted. Take for example the defense companies or Saraya Difa, which were commanded by the brother of Hafiz al-Assad, the former president. In the 80s, who is now residing in Paris, in France, that you can see that it's very evident that no one can persecute such big people, let alone the mid-level or low level people. Nowadays, you see a lot of we are seeing a lot of also trial cases applying international jurisdictional law like in Germany, in France, of kind of trying to bring those violence perpetrators to justice, but these are very low scale levels. Another example is how, in my case, I traced some of those brokers who were kind of, granted kind of diplomatic passports, and they are roaming around. A couple of them were in Romania before the lockdown. So you see them flying all over the place. So that is also like a very clear example for like setting an example for the future and also for current kind of recruitment, that if you join, you are safe. No one would persecute you. So in addition to impunity is also reward. I think this is key and guarantees.
Thank you. Matthew?
Yeah, I would just add, as mentioned by Iva and Ali, it's seen as a low-cost vehicle to carry out potentially state aims. There's also a market dynamic, which may also be a causative factor in the increasing use of not just paramilitaries, but private military contractors, because you don't necessarily have to pay pensions, you don't have to pay healthcare. They organize these groups using various financial structures. So there's also quite a financial incentive that may just continue to increase, that goes hand in hand with that deniability for actual criminal responsibility and state responsibility. So that's where I see a rather bleak picture emerging.
Thank you. The next question is addressed to Ali, and it goes, what about the hundreds, if not thousands of militias that are fighting the Assad regime? Can they also be classified as paramilitary groups? Do they share similar characteristics with the paramilitary groups that are fighting on the side of the regime?
Thank you for this question. I would like to just clarify some terminology, because if we talk about paramilitary groups, this exclusively concerns that groups that are operating for the state or on behalf of the state, while the other terminology or other armed groups are classified as rebel groups. So this, just to clarify this kind of nuance or difference between these two terms, and in terms, there are a lot of similarities in terms of actually recruitment. So they both kind of depend on the social networking, kind of gains, incentives, motivations, and most of the time also geography. Because, for example, if it happens that the opposition would be in control of X area, the rebel groups recruitment would be higher than regime or state recruitment. So also geography plays a significant role in the recruitment. But if we want to call them as paramilitary groups, this term is not applicable, because this is exclusive to groups that are fighting on behalf of the state, or it's paramilitary. So it's a kind of an organization that fights on behalf of the regular forces or an auxiliary one.
Thank you, Ali. This is a question to all of you. In the new book edited by Ezekiel Heffes and others on non-state actors and IHL, it is in general argued that NSA or non-state actor armed groups should be recognized a right or authority to detain and possibly adjudicate in order to promote the respect of IHL among non-state actor groups. Some authors also argue that such authority should also be recognized in order to prosecute the leaders of non-state armed groups for command responsibility, so the duty to punish. So what's the panelist's view on this? Isn't there the risk, due to the ambiguities of these groups, that by delegating sovereign rights to non-state armed groups, we may have the opposite effect, and so more arbitrary detentions and unfair trials? So who would like to take this question? I also see, by the way, that we still have 2 more questions for Matthew. So maybe Ali and or Eva would like to
I will
take this
gladly
one.
pass this on to Matthew because he's our resident lawyer. So Matt, you know.
It's certainly a legal problem that's been increasingly the center and subject of debate in recent years, that IHL doesn't have explicit provision authorizing or empowering non-state actors, armed non-state actors, to detain persons. And you can think about the obvious practical impact, which is they're going to be put in a position, at least legally, of saying either release or kill. And that's got its own cost, how it may occur. In terms of delegating powers traditionally provided to the state, I mean, international humanitarian law, in recognizing to a certain degree the status and obligations of non-state actors, at the same time, typically, and this is conveyed in the jurisprudence, is without prejudice to the question of their actual status as a lawful entity or maybe their claims to statehood in some way. So we try and separate those questions to avoid getting into public international law questions as to the legitimacy or the status of the group in question. At the same time, for the superior responsibility question that was, I think, part of that question, there are difficulties because superior responsibility, so whether that's under Article 7.3 at the ICTY or Article 28 at the ICC, has this element of superior subordinate relationship. And there's, in cases, for instance, Sheshel, who's, you could say, a paramilitary leader, Article 7.3 superior responsibility wasn't even charged. I guess there was a view of there would be difficulties in trying to prove that superior subordinate relationship. And then there's an issue of if the commanders change, and do you have successor commander responsibility? And the jurisprudence excluded this in the Hadzi Hasanovic case, which meant that you could interchange your commanders and after the crimes have occurred, and therefore in some ways avoid liability at the higher levels. And the jurisprudence is quite restrictive. There were terms like substantial influence is insufficient. So even if your head of your paramilitary group has substantial influence over the members, that's not enough. And control between one person and another of equal status is insufficient. So it really is quite a strict requirement. Now this is as it's been applied at the ICTY and doesn't necessarily bind any other tribunal, but it does show that there are difficulties when you try and apply these constructs to less regularly organized groups.
Thanks, Matthew, for this very elaborate answer. I see that there are very interesting technical legal questions coming in, especially for Matthew. The next one as well, talking about the Stanis case, would you agree that the prosecution, while saying that it is using a joint criminal enterprise against the accused, is actually trying to conceptually relate the facts to superior responsibility, while being unable to prove superior responsibility, therefore settling to prove the relatively easier GCA?
In which case? Sheshel?
Stanisic.
Stanisic and Samatovic,
Yes.
I presume. I mean, so the question is whether they're trying to use JCE in lieu or in the absence of Article 7.3. There's a difference in theory and in the elements between these modes of liability, and joint criminal enterprise, as it's been applied at the Yugoslav tribunal, is a plurality of persons, or more than one person, and common criminal purpose, and the significant contribution of the accused. Whereas as it's been applied at the tribunal, superior responsibility doesn't require that plurality. It doesn't require a common criminal purpose, any kind of intent element. So actually in some ways, it's harder to prove joint criminal enterprise in some ways because you need to prove the intent on the part of the accused. So for Stanisic and Samatovic to be convicted of joint criminal enterprise, its primary form, they would have to have the intent for at least some of the crimes that are charged against them. And whereas superior responsibility is more stringent in some other ways, such as the superior subordinate relationship, but it's less demanding because all they have to have is knowledge of the crimes that are occurring or are likely to occur. They don't have to have the intent per se for the crimes. So I think they're different modes, and obviously it was determined that JCE was more applicable, more appropriate, and now it will be up to the judges to decide at the end of the case if that's correct. But it's true that Article 7.3, as far as I'm aware, is not on the table for that case.
Thank you, Matthew. In view of the time, let's maybe have these final two questions as well. I think it would still be possible. Again, for Matthew, the question goes, I was wondering about the possibility of determining the existence of a state policy as an element of crimes against humanity for crimes directly carried out by paramilitary groups at the ICC. So could the deliberate failure to take action exception play a not exclusive but more prominent role here? And I'm asking this in the context of the Colombian paramilitary groups which often committed crimes in highly militarized areas where there was nevertheless no intervention.
Okay, well, I'm ignorant as to the detail of the facts in Colombia, so I can only talk about the law in the abstract. And there, for crimes against humanity, under Article 7 of the Rome Statute, it's a state or organizational policy. So it doesn't have to per se be linked to a state. In the context of the former Yugoslavia, as long as you had an organization that wouldn't even necessarily need to be de facto or quasi-state, as long as it was an organization, you could have met that element. Now, as a legal factor, it wasn't required strictly at the ICTY, but so the question about what is a sufficient organization came up in the Kenya cases at the ICC, and they talked about entities capable of carrying out these types of human rights violations on a scale sufficient to come within the jurisdiction of the court. So they didn't narrow it down to a state or a quasi-state or a de facto state of any type. It could there's a range of organizations that could meet that determination. And when you look at paramilitary organizations, you can see the wisdom of not narrowing it down too far, because there are as many organizations of paramilitaries as there are various ways in which they end up committing atrocities and crimes, unfortunately.
Thank you, Matthew. Maybe one question for Iva in between, before I give you the final legal question, Matthew, and maybe also Ali could answer this one. So Iva and or Ali, could you identify the motivations behind some movements' intention to commit specific forms of violence?
Well, I can say a couple of words there. So for example, for the former Yugoslavia, and this is something that we replicate and we see in research elsewhere as well, there are certain factors that influence member behavior across the board. So for example, consumption of alcohol and drugs has been linked to specific kinds of behavior, and also, for example, sadistic violence. And for example, in the former Yugoslavia, we saw units where alcohol consumption was, for example, ubiquitous and something that was done kind of on a regular basis. And there were units who were much more strict and much more military-like, I suppose, in how they carried themselves, but also I think how they perceive themselves. So for units and for members, and I should really stress, not every single member of every single unit is a murderer per se. So there were people who managed to sort of stay at the edges of crimes and kind of, you know, extricate themselves, I guess, to a certain extent. And there were always groups, smaller groups within a unit that were sort of leading the way. But one factor I would say is that if a unit considered themselves sort of professional, sort of special forces type of unit, they were less likely to torture, I think, due to 2 or 3 main reasons. One is that they really didn't have the time almost for it. They had other things going on, for example, fighting in the field, or they were less likely to drink and do drugs and therefore maybe do things that otherwise they wouldn't. but also torturing people, I would say also it takes time, and not every unit has that time. And for example, the yellow wasps, when they are in a detention unit for days on end with detainees, they fill their time sometimes with sadistic torture, so to say. So I would say that, just to reiterate, it has to do with the purpose and the nature of the unit themselves, and also the time they have on their hands, and how likely, for example, they are to be on drugs, high or drunk, for example.
I would like to add, in the Syrian case, actually, or in Aleppo specifically, there were some or various motivations. First of all, like access to resources. Most of the time, you have recruits from the countryside, and I'm focusing on the students component of these groups. So most of those who are from the countryside would like to pursue their studies at the university. They don't have access to accommodation. So one thing is like the first thing that they can get a room at the university inside. So this is one thing. Also, they are paid. They are like freelance or daily workers. For every mission they go or they take part in, they get kind of a compensation for. So that is also very significant. Like for them, like one of my informants was telling me that is very cheap. I go two days a week, and then I get my it's like a salary for the whole month. Another thing is prestige, because they can carry weapons inside the campus. They can brag. They can hang out with girls inside the university. So that is very like a status elevating thing. And at the same time, some of them are joining these groups for revenge, because they have been exposed to some rebel groups kind of violence, or etc. So they join these groups to take revenge. So there are various actually motivations, and the list is long, but these just like to mention some like that are related to the students.
Thanks a lot, Ali. The last question, and I will combine actually the two questions that are still on the screen, and these goes to Matthew again. So the doctrine of superior responsibility seems to have developed with reference of regular forces, and the use of notions such as command and control may be problematic for the prosecution of paramilitary members and also opposition groups that are organized in a non-hierarchical way. Do you think these concepts of command and control can be expanded as to include non-hierarchical groups appropriately, or should international justice seek to apply other concepts to prosecutions of this type of armed group? And it's a bit related to this question. The final question was, when one of the characteristics of paramilitaries is a lack of formal chains of command structure, then how can the contextual element of an organizational policy for crimes against humanity be manifested?
Mm-hmm. So at the outset, I think that superior responsibility remains a potentially useful vehicle, potentially useful mechanism for these types of crimes. It doesn't necessarily require formal de jure superior subordinate command. So it can extend to de facto situations, but you do have to prove that there was such a hierarchical relationship, albeit just on those specific facts. And I think it is a useful concept, and I don't think it should be jettisoned just because of the problems that have arisen, because sometimes intent is hard to establish, direct intent, and sometimes people, high-level leaders, do use these groups or allow them to operate and fail to take the reasonable measures to prevent and punish them, to report them properly to the authorities, and benefit, so they're allowed to have their cake and eat it at the same time. And so that superior responsibility can be an appropriate vehicle to hold them responsible for that lack of serious observance of their duties, typically the duties that we see reflected in humanitarian law. So I certainly would see it as a potentially useful vehicle, but it reinforces, to my mind at least, the need to really deeply analyze the structures that you're dealing with at the outset, to understand them, and to be on top of their shifting personnel, shifting nature, and try and identify if there is a coherent structure, or if not, if you're at the point of just a rabble who is disorganized, and so be it. It doesn't meet one of the elements. That's then it shouldn't be charged. So I certainly would counsel deep analysis in order to determine the most appropriate vehicles for responsibility. And I think the policy argument dovetails with the one of the previous questions. And again, international criminal justice, as it's been applied so far, doesn't require a formal de jure policy and like a party manifesto with written bullet points. It can be a set of, let's say, coherent values, ideas, motivations that develop during the course of the crimes and events. And there is a footnote in the Elements of Crimes, I believe, that talks about deliberate failure to take action. So you could establish a policy based on inaction, but you would have to show it's deliberate inaction. It's not just mere inaction.
Thanks a lot, Matthew, for this very clear and elaborate answer again. In view of the time, I would like to conclude. I think this has been a very interesting webinar, and I'm sure the viewers, including myself, have learned a lot. So a big thank you to Iva, Ali, and Matthew. I would also like to thank our co-organizers, the Coalition for the ICC, the Grotius Centre for International Legal Studies, and the IHCL platform. And I should not forget, of course, the events and communications team at ASSER for setting up this very first online SCL lecture. And finally, I would like to thank you and the general public for watching from home. I hope you found it interesting as well. And if you want to rewatch certain parts or the entire thing, this webinar has been recorded and will be placed on the ASSER website. Finally, I would like to take this opportunity to point you to 3 online events that the ASSER Institute is organizing the coming weeks and that may be of interest to you. So next week on the 10th of June, we'll organize a highlight lecture on how the Syrian conflict has changed international law. Then on the 15th of June, we'll have an event on the Office of the UN Ombudsperson to the ISIL, Daesh, and Al-Qaeda Sanctions Committee. And 2 days after that, on the 17th of June, we'll launch the book Human Dignity and Human Security in Times of Terrorism, which I co-edited with Professor Martin Scheinin from EOI, who will also join our digital launch. And for more information, please have a look at the ASSER website, or better, sign up to our mailing list. So thanks again, see you next time, and stay safe.